my screen. Just 1 minute to find. Yes. So I suppose that now you have you can see my screen. Is it okay for you?
Yes, I think it's fine.
Thank you. So, of course, if students have questions, don't hesitate to ask the questions if you want to talk or to use the chat, and at any time. So, as John said, my first class deals with commercial exploitation of space resources. And considerations on the evolution of international space law. So during this first hour, I will make a brief introduction to space law, just in case some of you have no knowledge about space law, and then we will go on with then we'll go on with the legal regime of space resources and the current discussions concerning a possible regime dealing with exploitation of, in order to regulate exploitation of resources of celestial bodies. So, first of all, just a brief presentation of sources of international space law through the normative dynamics. We can divide the period of development of international space law into three main parts. The first period from 1967 to 1979 is a period by which states decided to adopt international treaties in order to avoid disputes and conflicts dealing with outer space. So the main object of international space law during this period is to support the exploration and the use of outer space by states. And we call this period the golden age of space law because during these 12 years, the main text, the 5 main international treaties have been adopted. The second period starts at the beginning of the 80s until the end of last century. States considered that the better way to continue with development of international space law is not to use any more international treaties. They prefer to adopt normative resolutions, which is a method based on soft laws, which is more in line with the sovereignty of states, and also to introduce international principles into national space laws. The object of the law here is to support the commercial exploitation of outer space and to have rules for the development of commercial activities in outer space. And since the beginning of the century, the third period of development of international space law is based first on the adoption of technical standards at the international level, but also at the national level, the modification of national space laws in order to encourage private companies to enter the space sector, to attract private investors into the space sector. And this is where the law concerning and the rules concerning exploitation of space resources comes into question. The two first periods are characterized by an approach called top-bottom, because the rules are first adopted at the international level, at the UN level, and then transposed at national level through national space legislations. So the origin of international space law is international law. The third period is based on another dynamics, which is called bottom-up. That is to say that international law reveals, I don't know if the wording is correct, but international law is based on an analysis of the best practices based on the national practice, the practice of the agencies, the practice of the industry, and the legal practice of states. And as a consequence, when the United Nations decided to recognize evolution of international space law, the United Nations uses this analysis, that is to say that the national law influences international space law. And this is also where the question of the regulation of exploitation of space resources comes into question. So you have to keep this in mind when we will see the rest of the question. So I don't know if you are aware of the main sources of international space law, but just to give you here a brief overview, during the first period, 5 treaties have been adopted. A framework agreement, the Outer Space Treaty, implemented by 4 specific conventions in order to address a dedicated issue, such as the rescue of astronauts, the liability for damages caused by space objects, the registration of objects launched into outer space, and the legal regime of the Moon Agreement, of the Moon and other celestial bodies. When states decided to move to normative resolutions, they adopted 5 texts that are not binding as such. The very first one has been adopted before the Outer Space Treaty, the Outer Space Declaration, which is, in fact, a first step towards the adoption of an international convention. But you see that after the Moon Agreement, 4 normative resolutions have been adopted in order here to address more specific issues, mainly satellite applications issues, such as the question of direct broadcasting by satellite, the observation of Earth by satellite, namely the remote sensing, the use of nuclear power sources for space missions, and the cooperation among countries, taking into account the needs of developing countries. And the technical regulations are composed of rules, as I said, that are based on the practice of industry and agencies. They are being adopted in the field of space debris mitigations, safety framework for nuclear power sources in outer space, and long-term sustainability of outer space activities. So these are the main sources concerning the main international sources concerning international space law. And now, what is the legal regime of space resources based on international space law? 2 texts are here very important. The first one is the Outer Space Treaty, in particular Article 2 of the Outer Space Treaty, which recalls that outer space, including the Moon and other celestial bodies, is not subject to national appropriation. by claim of sovereignty, by means of use or occupation, or by any other means. That is to say that it is strictly prohibited to have appropriation over the moon or part of the moon or over a celestial body, another celestial body, or part of another celestial body. And all forms of appropriation are prohibited, not only the appropriation by means of sovereignty, but also the appropriation by exploitation or occupation. And it concerns appropriation by states, but also appropriation by private companies. The second treaty is the Moon Agreement, and it's Article 11, which considers the moon and its natural resources are as the common heritage of mankind. As a consequence, because the moon and its resources belong to everybody, states parties have the obligation to establish an international regime in order to regulate exploitation of resources of the moon as soon as this exploitation is about to become feasible. That is to say that in order to organize the commercial exploitation of resources of the moon, a dedicated regime has to be established by states parties to the Moon Agreement. So the regime here is very similar with the regime adopted by the law of the sea concerning the deep seabed. The Convention on the Law of the Sea, adopted in 1982, has not only confirmed that the resources of deep seabed are common heritage of mankind, but the convention also established an international organization to provide authorizations to explore and exploit natural resources of deep seabed, which is not yet the case for the moon, because this regime is not yet established. So this is for the future, but right now, states have the right, based on Article 6, to exploit resources of the moon to support their activities on the moon. That is to say that states, companies have already today the right to appropriate resources to, for example, to build moon stations or to generate energy or water for moon missions. This is not prohibited. It is protected under Article 6 of the Moon Agreement. So the Moon Agreement is quite equilibrated. You see that there is a regime for the future, which has to be established. But since now it is possible to use minerals and other substances for the support of scientific missions or other missions on the moon. The problem is that the Moon Agreement was not a success, was not a diplomatic success, and now I will explain you why the Moon Agreement cannot be used as a basis for the regulation of the resources of the moon and other celestial bodies. So first of all, the Moon Agreement is based on a project supported by Argentina and other developing countries. So the project was sponsored by developing countries in line with the right to development, which was at the period in the 70s, very important at the UN. So Argentina presented a draft convention on principles governing activities on the moon and concerning resources of the moon and other celestial bodies. And for the very first time, the document was introducing the concept of common heritage of mankind. Don't forget that in parallel, there were the negotiations on the law of the sea, where the concept of common heritage of mankind was also part of the discussions. The problem is that the Soviet Union proposed a counter-project, a draft convention on a general legal regime applicable to the moon, but excluding specific provision on lunar resources. In fact, the position of USSR was against any right of property on the moon and on the resources of the moon. And USSR refused at that time to transpose the concept of heritage into international law, considering that the concept of heritage is based on civil law and is foreign to socialism and socialist approach of international relations. So developing countries tried to convince the Soviet Union to discuss the concept of common heritage of mankind. And finally, because the US government was in favor of the adoption of the treaty with the concept of common heritage of mankind, the USSR accepted the proposal made by the US. That is to say, let's adopt a treaty on the moon, but we will discuss the concrete regime of exploitation of the resources later. We don't have right now to decide what would be the organization, the international organization, to manage exploitation of the resources. So the deal is to say, we adopt a treaty, including the concept of common heritage of mankind, but we will discuss later on when the concrete organization of the exploitation of the resources. So the text has been signed, not by all, but at least the text has been adopted. Then there was a debate at the US level, because in the US, the space community considers Article 11 of the Moon Agreement as contrary to US interests. So you have to understand that at that time, there was a strong disappointment of the space sector following the end of the Apollo missions, when the US government decided to terminate the Apollo missions, the missions that conducted the US to go to the moon and to develop moon activities. These missions, they are very important and symbolic for all the space community. So when the US government says, we don't have now enough budget to continue activities on the moon, it was there was a lot of confusion for the space companies, the space sector, of course, the NASA, but it was a reality. Activities on the moon are too expensive, and in fact, because also the US went to the moon just to show that they were better than the Russians. So there was no real objective behind an objective of communication and marketing. They went to the moon to say we are the best. So it's too expensive to continue to go to the moon just for a question of image. So they decided to terminate the program. As a consequence, the space industry hit by a series of layoffs and lost confidence in its administration. And when the Department of State proposed the signature of the Moon Agreement, the space industry, the space community said, oh no, it's not a good signal. We don't want this agreement to be signed. So there was an intense lobby against the Moon Agreement in the Senate, with the support of the technophile community, and also keeping in mind the discussions on the law of the sea. Finally, it has been decided that the common heritage of mankind is not a good concept, and because it will generate legal and security, it is better to not sign the Moon Agreement. So the USA refused to sign the Moon Agreement, and the Russians said, okay, if the US don't sign, we don't sign. Anyway, we did not want this agreement. This agreement is not a good agreement. So no spacefaring nation accepted to ratify the Moon Agreement. So the Moon Agreement is in force today, but because none of the spacefaring nations have accepted the text, it's not effective to regulate activities on the moon. So now that you have understand that there is the Outer Space Treaty and the Moon Agreement, but the Moon Agreement is not really applicable, you will understand the US legal strategy. Because in 2015, USA decided to change the status of international space law by adopting a national act, the Space Resource Exploration and Utilization Act, by which the US government authorizes private persons to proceed to commercial exploitation of resources of the moon or the celestial bodies, including the asteroids. Following the decision of the US to authorize such activities, 3 other countries adopted similar legislations: Luxembourg in 2017, the United Arab Emirates in 2019, and more recently, Japan in 2021. 4 national legislations, almost similar, adopted to authorize commercial exploitation of resources of celestial bodies. What is the legal basis? These states consider that they are in line with the Outer Space Treaty. They expressly recall the Outer Space Treaty, considering that they are not violating Article 2 of the Outer Space Treaty. Why? Because I show you previously the drafting of Article 2, and when you read carefully Article 2 of the Outer Space Treaty, you will see that the term resources does not appear, that the article deals with outer space and celestial bodies, but does not address the issue of resources of celestial bodies. So the US government consider that the Article 2 prohibits appropriation of the moon or part of the moon, but does not prohibit exploitation of the resources. It's not the same based on the US interpretation. You cannot appropriate the moon, but you have the right to exploit natural resources of the moon. And in addition to that, such activity would be protected under the principle of freedom of outer space, which is proclaimed by Article 1 of the Outer Space Treaty. So you see the logic behind the law. The Outer Space Treaty does not prohibit the exploitation of resources of Moon, because Article 2 on non-appropriation of outer space does not address the issue of the resources. And Article 1 of the Outer Space Treaty, based proclaiming freedom of outer space, protects such activities. In addition to that, US recalls that the Moon Agreement is not applicable because it's not ratified by the USA. So you see the position of the US, it's clear, maybe it's convincing, maybe you are convinced by such interpretation, but in international law, a state has not the right to interpret a treaty on behalf of the state parties. The rule is that states parties have to have a common interpretation of the rules of a treaty. So the position of the US to say, this is our position, this is our interpretation, and this is the right one, does not fit with international law of treaties. The solution has to come from a common interpretation given at the UN level. The problem is that the US government tries to bypass the United Nations by encouraging the international community to confirm the interpretation of the USA. How? By proposing the signature of the Artemis Accords on principles for cooperation in the civil exploration and use of the Moon, Mars, comets, and asteroids for peaceful purposes. The Artemis Accords have been officially signed in 2020 by 8 state representatives, but today 15 additional states representatives signed the document. And you see here the list of the countries that have signed the Artemis Accords. Here maybe you have a better overview. And some of these countries are very important because they are countries that are very active in the debates at the United Nations. In particular, Mexico, Colombia, and Brazil usually represent the voice of developing countries. So the fact that these countries have signed the Artemis Accords shows that the position of developing countries may be favorable to the American position. Another country which is very important here is France, because not only France has signed the Moon Agreement, but also France is one of the main spacefaring nations in Europe. And the President Macron, our current president, accepted the signature of the Artemis Accords, despite a debate at the French Parliament, because the extreme left parties, which is very strong in France now, made a statement, a public statement, in order to not sign the Artemis Accords. So there was a political debate in France between the present government and the extreme left party, which party against the Artemis Accord. Nevertheless, the president decided that France has to sign in order to support also its industries and have the possibility for French industry to participate to the Artemis program of the NASA. So the content of the Artemis agreements, some principles are just confirming principles already proclaimed by the international space law, that is to say, the exclusive peaceful use of celestial bodies, the exchange of scientific and space policy information concerning moon and other celestial bodies, the assistance to astronauts in the event of distress, the registration of space objects, the prevention of activities harmful to other states, and space debris mitigations. So these principles are both in the Artemis Accords and in other texts of international space law. You have also new principles that are compatible with international space law under certain conditions. First of all, the preservation of historical sites on celestial bodies. This is an important issue for the US. The preservation of historical sites and celestial bodies means the protection of the sites where previous missions landed, in particular the mission Apollo, the first mission Apollo to reach the moon. So the idea is to protect these zones because they represent a historical site. The main question is how to protect these zones, because it's not possible to register such zones at the UNESCO Heritage Convention, because the UNESCO Heritage Convention only protects sites that are on the territory of states. So we need to find a way to organize the preservation of these sites. But if we can find this way, I don't see any objection regarding international space law. This is a more interesting issue. The Artemis Accords organizes security zones to protect activities on celestial bodies. Well, the establishment of security zones, that is to say around moon bases or moon installation, is not mentioned in international space conventions, but it won't be in contradiction with international space law if it is still possible to access to all zones of celestial bodies, because international space law protects access to all zones of celestial bodies. So in order to implement security zones without violating the principle of freedom of movement on celestial bodies, there must be some procedures by which you can organize the protection of a zone without restricting the movement of vehicles or astronauts of other countries. Another question is that security zones cannot be permanent. If they are permanent, they represent a sort of appropriation of the moon by occupation. So they have also to be limited on time. the development of interoperable infrastructures and standards. It's a common rule. When you develop a cooperation in outer space, you need interoperable infrastructure and standards. But the risk here is that the US government imposes its standards as the international standards, because of course we will work with the US. The US will bring the main infrastructure, the main resources for the future bases on the moon. So Europe has to be sure, and other countries have to avoid to be obliged to adopt American standards. We have also standards in Europe. Other countries have standards. So the standards have to be interoperable, but not the same, not necessarily the same. Then you have absent principles from the Artemis Accords that yet are required by international space law. First of all, the planetary protection, which is a very important principle. Planetary protection means that states have to take measures to avoid harmful contamination of celestial bodies by cleaning procedures or quarantine procedures. But we don't see such obligations in Artemis Accords. And there is no provision concerning liability for damages to celestial bodies or on celestial bodies. And then, of course, there is a principle whose compatibility with space law is disputed. It's a question of exploitation of resources of celestial bodies. So now, and I will finish with this point before to open the debate with the students. What is the debate at the UN? At the UN, the debate is now on the agenda of the Committee on Peaceful Use of Outer Space, the COPUOS. And at COPUOS, there is a strong opposition made by Russia. Russia considers that the Artemis Accords, that the US space legislation, and also the legislations of the three other countries that are authorizing exploitation of the resources is contrary to international space law. In addition to that, in 2021, China and Russia adopted a memorandum of understanding in order to develop cooperation for the construction of an international lunar research station. We don't have the text of the memorandum of understanding. I did not have access to the text, but from what I know, the two space agencies, the Chinese National Space Agency and Roscosmos, accepted to adhere to the principles of consultation, joint construction, and shared benefits, which is maybe more in line with the principles of the Moon Agreement. Finally, a working group has been established last year on general exchange of views on potential legal models for exploitation of space resources. I say finally because it was very difficult to find consensus at COPUOS concerning the establishment of this working group, since the US government was against such working group. And then there was the COVID crisis, so we had to slow down the debates at the UN. So last year, the group was established, and you have here the mandate of the group. You see, the group has to collect relevant information, to study the existing legal framework, and to develop a set of recommended principles. And the group will achieve its work in 2027. That is to say, a very long period of time, during which the US government will continue to promote the Artemis Accords. And as far as I'm concerned, I consider that in 2027, there will be no other option than recognizing Artemis Accords as the state of international space law. We will have more and more countries that will sign the Artemis Accords. So unfortunately, for those that wanted maybe a solution based more on international cooperation, at least those who wants the UN play a role here, I think that the US strategy at the end will be the one, and that the legal regime of exploitation of resources on the moon will be based on the Artemis Accords. So thank you very much for your attention. We have now time, John, for some questions.
Thank you very much, Professor, for your insightful presentation. It was very interesting to see all this legal framework of space law, which is essential in order to understand more complex issues such as space exploitation and utilization. Now we're encourage our students to ask any questions that may arise to Professor Philippe Achilleas. Is there any question, something that you would like to discuss in more detail? So maybe it was a question before from one of our students who was wondering why China didn't adopt any national legislation regarding the commercialization or exploitation of space resources. And as United States or Luxembourg, Japan or United Arab Emirates has already adopted similar legislations, why some other states, such as China, didn't proceed to any such legislation yet?
Yeah, thank you. So other countries are now considering adopting national space legislation on space resources. And the next law will be the one of Saudi Arabia. Currently, France is amending its national space law. But there is a debate to know whether or not the new French Space Act will introduce an authorization for activities on celestial bodies. So there is a movement confirming the position of the US. Well, the position of China is very ambiguous at the United Nations. I mean, China for sure wants to be part of the game, and for sure China wants to also have the possibility to exploit resources of the moon. And to be honest, it is not possible today to propose the development of the moon base without the exploitation of the resources, because to live on the moon, to support activities on the moon, you need to use moon resources. Okay, so for sure, China wants also to have such activities. But from a diplomatic point of view, it's complicated for China to be in line with USA. And also to being in line with USA means that you are not supporting Russia. So China plays a game which is I don't say anything. I propose my moon base, but I don't enter officially in the debate. I don't need law because why USA, why the other countries are adopting such legislations? It's because they need to authorize private companies. But the model of development of China for the moon is not yet based on private companies. So China does not need an authorization regime for its administration to go to the moon and to use the resources. So at the moment, they are not it's not the same way of development. Why USA adopted the act in 2015 is to give a signal to the space industry, to say to American space industry, okay, you can go to the moon, you can invest on the moon, and we are happy to have you on the moon. And look, we are supporting you by adopting a framework to clarify the legal regime of the moon for you, private companies, American private companies, to go there and to start commercial activities. So you see, it's not, and also another point is that China does not need the money of private sector to develop its activities on the moon, but the US government knows that without the private sector, it is impossible to have the budget necessary to go on the activity of moon exploration. I don't know if I'm clear. I see a question from Chris now.
Yes, it's another question.
Are there any specific legislation for exploitation of Mars and other planets of our solar system? Because in my opinion, they already use legislation when inspired. Yeah, but if you read carefully the legislations adopted by the US, Luxembourg, and other countries, it's more comprehensive. It includes not only the moon, but also other celestial bodies. So from the viewpoint of national space legislations, the legislations concerning resources of celestial bodies are applicable to Mars. But there is another issue which is interesting, Chris, is that we have the Moon Treaty. And the Moon Treaty is today applicable also to Mars, unless a future regime on Mars is adopted. So maybe that in the future, there will be a dedicated international regime for Mars. I'm not sure, but it's also an option, because today the Moon Agreement is also applicable to Mars until a dedicated convention is adopted for Mars activities.
Okay, thank you very much. Maybe if there is no other question for now, we could take a 10 minutes break, and then we'll be back at 8 and 10, and
yeah, in the
time it will be 7.
In Paris, it will be 7. You mean in 10 minutes or in 15 minutes?
Let's say in 10 minutes.
10 minutes, because the last class is a little bit more complicated, more technical. So we have a 10-minute break. Thank you very much. So switch off my cam, and I come back in 10 minutes, okay?
Yes.
Okay, Christopoli.
Thank you.
So again, I will share my screen now. Where is it? 1 minute. So I will continue with commercial exploitation of spectrum orbit resource, which is a question quite complex and technical. So I will try to be as clear as possible, and I will not go too deep in the regulations, because the main issue is to understand how it works rather than to know all the rules. So after an introduction, I will present you the legal status of space telecommunication resources, and then the legal regime for the use of space telecommunication resources. So first of all, here we are moving from international space law to international telecommunications law. The rules are developed under the responsibilities of a dedicated international organization, the International Telecommunications Union, which is the UN specialized agency in the field of telecommunications and information society. Within the ITU, within the International Telecommunications Union, a dedicated department, we call it the International Telecommunications, or like radio communications, is responsible for satellites. And within this department, the Radio Communications Bureau is the body which coordinates the use of the frequencies and the use of the orbits, in particular the geostationary satellite orbit, in order to prevent harmful interferences between radio stations of different countries. So within the ITU, International Telecommunications Union, the radio communication sector is responsible for space communications, and the Radio Communication Bureau coordinates the use of frequencies and orbits. The sources of ITU law are based on three main documents: the ITU Constitution of 1992, the ITU Convention of 1992, and the radio regulations. That is to say, a set of technical regulations that are modified on a regular basis by radio communication conferences. The last conference was organized in 2019, and the next conference will be organized this autumn at Dubai. So what is the spectrum orbit resource? In fact, it's a combination between frequencies and orbits. When you launch a satellite into orbit and you want to communicate with the satellite or through the satellite, you use a combination of two resources: spectrum, so the frequencies, and orbits. Okay. We call it the spectrum orbit resource. Okay. So the spectrum, the frequencies, are the radio waves that allow information to be propagated in space without cable, without any physical infrastructure. So the satellites receive information, transmit information, or collect information, distribute information without cables. There is no physical infrastructure going from Earth to outer space. So the only way to have communications via satellite is to use electromagnetic waves, okay? And in international law, the spectrum, that is to say, the radio waves available, is limited to 3000 gigahertz, because if you use other frequencies, there are other frequencies than the frequencies limited to this range of hertz, but you cannot use them to communicate. So you see that electromagnetic waves is limited in terms of frequencies. We don't have infinite resource, because if you want to communicate, you can only use these frequencies. Okay, so this is the first resource, the spectrum. The second resource is the orbit, because a satellite, in fact, is orbiting around the Earth. Okay, so satellites are placed into different orbits depending on the nature of the service. For telecommunications, we use the geostationary satellite orbit. That is to say, an orbit which is located at 36,000 kilometers from the surface of the sea. And at this position, the satellite keeps a fixed position regarding the Earth. That is to say that the satellite is rotating at the same speed than the Earth. So it's very convenient to have permanent communications, and also to broadcast programs via satellite. But if you want to provide high-speed connectivity, and use the orbit located at 36,000 kilometers from the Earth, is not the good one, because there is a delay, there is a time delay between the time where the information is sent to the satellite and the time when the information is received on Earth. So for providing high-speed communications, you need to use medium Earth orbit or even low Earth orbit. The orbits are closer to the Earth. The problem is that when you place a satellite at medium Earth orbit or low Earth orbit, they move at they go faster than the Earth. So to have permanent information, to have a permanent service, you need to launch several satellites that are orbiting together. We call it constellation of satellites. You see, so it's not very complicated, but you have to know why we are using a satellite and to place your satellite at the right orbit regarding the service on Earth you want to provide on Earth. So the spectrum orbit resource is composed of the frequencies and orbits in outer space. So what is the legal statute of space or communication resources? First of all, these resources are limited natural resources. It is expressly mentioned by the ITU Constitution, the radio frequencies and the geostationary satellite orbit are limited natural resources. As I said, for the frequencies, we cannot expand the number of frequencies available for communications. And today, we use more and more frequencies because we are living in a world of permanent connectivity, because we have all our mobile equipment on like mobile phones, computers, etc. We use more and more frequencies, and we can't add new frequencies to communicate. So the spectrum is a limited natural resource. Concerning the geostationary satellite orbit, which is very important for telecommunications and broadcasting, here again, it's just a unique orbit at 36,000 kilometers from the surface of the sea. So, no, it's not here, excuse me. So the orbit is already fully occupied. So there is no slots or very few empty slots on the orbit. So if you want to avoid harmful interferences, you need to have some space between each satellite. So now, today, to find an empty slot to place a satellite to communicate is very, very complicated. So for these reasons, we also consider the geostationary satellite orbit as a limited natural resources. In addition to that, these resources are international because they are located in outer space. So the principle of non-appropriation is applicable to space frequencies and to orbits around the Earth. So Article 2 of the Outer Space Treaty on Non-Appropriation is applicable. But in 1976, 8 equatorial states signed a declaration at Bogota claiming sovereignty over the part of the geostationary satellite orbit located above their territories. So, of course, spacefaring nations recalled Article 2 of the Outer Space Treaty. ITU said it's not a question of telecommunications law; it's a question of space law. So we will not debate the question. But at the United Nations, it has been recognized that the Outer Space Treaty and its Article 2 invalidate the Declaration Bogota. So it is, even though there is no official solution to the debate, we consider that because the geostationary satellite orbit is located in outer space, excuse me, and despite the absence of definition of outer space, no state can claim sovereignty over part of the geostationary orbit. So now, what is the legal regime for the use of space telecommunication resources? So I will here briefly present you the rules. I have simplified the ITU procedure because it's too complicated. First of all, we will see the prevention of harmful interferences. Then we will see the equitable access to radio resources. And I will finish with the limitation of commercial speculation on spectrum and orbits. So, one of the main objectives of the ITU is to prevent harmful interference. Harmful interference is defined by the ITU Constitution, and it means that you have interruption or degradation or interruption of or a bad communication between stations. Okay, so because you have two frequencies are used in a bad manner, you cannot communicate. You block the communication between stations. So ITU Constitution asks states to avoid harmful interferences when they operate radio stations. So in this case, you have two satellites, one satellite located on the geostationary satellite orbit, and the other one a non-geosat. And the two satellites are providing telecommunication services on Earth. And you see that they can, at the same time, provide services, but also jam other services. So there are risks of harmful interferences blocking the provision of the service on Earth. And it's what we try to avoid. We try to avoid such situations where the frequencies of two systems are overlapping and blocking the provision of communication services. So in order to avoid harmful interferences, ITU has established a procedure. Now we have also special rules for non-geostationary satellite orbits, special rules for small sats, and there are also obligation to act in case of jamming. The procedure is based on several steps, 3 steps. The objective is to share the frequencies among all users to be sure that there will be no harmful interferences. So how to share the resource between all users? First of all, by the procedure of allocation of frequency bands. I will explain you how it works and what does it mean. Secondly, through an authorization to use frequencies, we call it assignment in telecommunications law. And last point, through international coordination. So first point, the sharing of spectrum by the allocation. At ITU, during international conferences, states decide how to share the frequencies among all services. The idea is to identify dedicated frequencies for dedicated services. So how? By dividing the spectrum into bands. We will have different frequency bands, okay? And each band will correspond to one or several services. So you see here an example of division of the spectrum, that is to say all the existing frequencies that can be used for telecommunications. And you see that we share the spectrum by bands. We give names to the bands. We use letters to identify each band. So we have a band for mobile communications, band for radio services, band for TV services, band for satellite services, a band for military services. So it's a first step to have a good usage of the resource by which each sector will receive dedicated frequencies. So let's say that you are a mobile phone operator, you will use the frequencies allocated for mobile services. If you are a satellite operator, we will use the frequencies dedicated to satellite services. For the army, some bands are dedicated for military uses of frequencies. So it's a first step, and this is done at universal level, at ITU, world conferences, and the sharing of the spectrum is the same for all states. So for the space telecommunications, we have different services and different bands. We have first what we call the fixed satellite service, that is to say, to have a transmission of information from a fixed station to a fixed reception station, okay? So it's from one point to another one. We have also another category of service, which is for mobile services by satellite. So all the mobile communications that are provided directly from satellites. And you see that these communications are not using the same frequencies than the fixed service. We also have frequencies used for broadcasting and video by satellite, and frequencies used to connect several satellites together. So all these services are using different frequencies. So it's a first way to avoid harmful interferences between services. Okay, a satellite operator providing mobile services will use dedicated frequencies for mobile services by satellite. If a satellite operator provides broadcasting services, the satellite operator will use dedicated frequencies for broadcasting by satellite, etc., etc. The second step is the authorization. The principle is that before to start to use a frequency, you need, as an operator, to have an authorization given by a national administration. The authorization is called assignment. So in each country, there is a national administration responsible for the assignment. So let's say that you are representing Eutelsat, which is a French company. So Eutelsat will request the authorization from the French administration. We have an agency dedicated for frequencies, the French frequency agency. Now, let's say that you are representing DirecTV, which is a satellite operator in the US. Then you will ask the authorization from the Federal Communications Commission. So it's not at ITU level, but at national level where the authorizations are given, okay? But before delivering the authorization, before issuing the license, because it's a kind of license, the administration shall ensure that there will be no harmful interferences with foreign systems. So there is here a procedure of international coordination made by all the administrations that may be affected by a project. Let's go back to the example of Eutelsat, which is a French satellite operator. Let's say that Eutelsat wants to launch a new satellite to provide communications over Europe and Africa. So Eutelsat will ask assignment to the French administration. But before the French administration gives the authorization, the French administration will send a copy of the project at the ITU, the International Telecommunications Union, where all the other administrations will be informed of the project of Eutelsat. If one administration considers that the project of Eutelsat may cause harmful interferences with existing networks, then there is international coordination. So it's a very long and complicated task, because sometimes you negotiate during years and years before to eliminate the risks of harmful interferences. Okay, but the problem is that you have a limited time based on ITU to proceed to coordination. You have 7 years to negotiate, and if you haven't finished the negotiations after the period of 7 years, well, you will not be able to register the frequencies. Okay, because after coordination, the last step is the registration of the frequencies by the bureau, by the ITU bureau. When the coordination procedure is over, when there are no risks of harmful interferences, the national administration will deliver the authorization, so we'll give the assignment to the satellite operator, and at the same time, the national administration will send a copy of the authorization to the ITU. And ITU will just check that there is no risk of harmful interferences with existing system. And if so, the ITU will register the frequency assignments in the international register. And as soon as the frequencies are registered at ITU, the frequencies are protected against harmful interferences. So the only way to protect internationally your frequencies against harmful interferences is to register the frequencies at the ITU. Okay, but there is another rule which is very important here, that when the administration starts the coordination procedure, the satellite operator has 7 years to operate the frequencies. So I said before, you have 7 years to terminate the negotiations, but it's worse. You have 7 years not only to terminate the negotiations, but also to launch and operate the satellite. If you don't use the frequencies after a period of 7 years following the beginning of the coordination procedure, you will lose the rights to not, the ITU will terminate the procedure, and you will not be able to register the frequencies. So it's quite complicated. Now, concerning satellite constellations, because it's long and very long to launch and to achieve the launch of the constellation within a period of 7 years, it has been decided to give 7 additional years for the complete deployment of a satellite constellation. That is to say that the satellite operators have to start the deployment of a satellite of the constellation within a period of 7 years. Okay, and then we give them 7 additional years with a timeline which is specific. You see it on the table here, to achieve the deployment of constellation. If they have not achieved the deployment of the full constellation by a period of 7 + 7 years, here again, the operators will lose their rights to not be interfered. Now, concerning small sats, the small satellites mainly developed by startups or universities, ITU considers that the procedure is too complex. It's completely disproportionate to go through this procedure. So the idea here is to simplify the rules for the launch of small sats. Okay, if the small sat is operated for a period not exceeding 3 years, and if the total number of constellation of small sats, if any, does not exceed 10. So in this case, we consider that it is possible to launch the small sats and to notify after the launch to the ITU. Okay, so it's just to simplify the rules for startups and universities that want to launch these small satellites. Sometimes, even with the respect of the procedure, you have harmful interferences. You may even have voluntary harmful interferences. We have some disputes by which countries try to block the reception of foreign programs on their territory by jamming the satellites. So in case of harmful interferences, states have to ensure interruption of services responsible for jamming. If not, there is a procedure of settlement of disputes at ITU, but ITU has no power of sanction. However, ITU can activate the International Emission Control System, which is a mechanism by which the ITU will identify the origin of the jamming. And ITU will name the country responsible of a jamming. And this is already a kind of sanction in a diplomatic sanction, when officially, expressly, the International Telecommunications Union says, you jam, you are responsible for jamming. Well, it's not a good statement. It's not a nice statement made by ITU. So usually states try to avoid such naming procedure. So I presented the rule, the procedures for using frequencies and orbits. But this procedure is based on the first come, first served principle, which benefited to industrialized countries and spacefaring nations. So in order to support the use of outer space by developing countries, ITU has also recognized the equitable access principle. The first come, first served principle means the first administration to start the coordination procedure is the first to be able to register the frequencies together with the orbits or the orbital position. So, of course, at the very beginning of the space activities, only only industrialized countries were proceeding to international coordination and to recording at ITU. The problem is, once you get the rights at ITU, you keep the rights until you abandon the frequency or the orbit. But usually, countries and operators they proceed to replacement of the satellite in orbit before the end of life of the satellite. So they continue to use the frequencies and the position. So it's like if they were keeping their rights forever. So developing countries said, well, the system is not working for us. The system works only for those that have the means to launch a satellite and to operate the satellites. So this is not a right system. We need to review the system. So ITU said, okay, and you see here the representation of the geostationary satellite orbit. As I told you, it is almost full. And when you see the list, the names of the spacecrafts, you can see that there are very few satellites from developing countries. So the ITU said, okay, we will change the rule. At least we will recognize the equitable access principle. That is to say that we will recognize that the orbits and the spectrum cannot be used only for industrialized countries. So we need to take into account the needs of developing countries. So how? By adopting plans for some frequencies. So it's a little bit complicated here, but I will explain you. The idea is to take some bands, not all bands, because it's not possible, but to take some bands and to share the frequencies together with the orbital positions between all countries. So all countries will receive rights to operate frequencies and orbits for national services, even if they don't have satellites today. When they will launch a satellite, they will still have the right to use these frequencies together with the orbits and orbital position associated. So we have two bands that have been planned, a band for direct broadcasting satellite services and a band for fixed satellite services. So for these two bands, and only these two bands, the rule is to share the resource among all countries, and countries will keep rights over the resource, even if they are not using today the resource. Okay, but for the rest of the frequencies, that is to say, almost all the other frequencies used for space, the rule is first come, first served. So I will finish with the limitation of commercial speculation on spectrum and orbit resources with a question called paper satellite. What is a paper satellite? A paper satellite is a satellite feeding for systems under coordination which do not represent real communication requirements. That is to say that some states will go through the procedure at ITU. That is to say that they will request frequencies and orbits coordination, but they have no satellite. They will never launch a satellite. The project does not exist. The only objective here is to register rights over frequencies and orbits in order to sell the rights to countries that have projects that need the frequencies to operate their satellite. And this happened for the very first time with the state of Tonga, which is an archipelago in the Pacific Ocean, a very small state. And in Tonga, a private company called TongaSat was established in the 90s and requested 16 orbital slots over the Pacific Ocean. But the idea was not to launch 16 satellites. The idea was to sell the rights to other countries of the region that wanted to launch their satellite. So TongaSat and Tonga blocked access to outer space because they had registered the frequencies for themselves without having satellite to launch. So ITU said, okay, now we will change a little bit the procedure. It is requested that administration send documents to prove the existence of a project in order to register the frequencies at ITU. And they have 7 years from the beginning of the procedure to send information. If information is not sent after a period of 7 years, then the ITU will stop the procedure and will delete the information registered. In addition to that, now states have to pay fees for satellite network fillings at ITU. Well, it's not that expensive, but still it costs now money to present a file at ITU. And I have finished my presentation. Ευχαριστώ.
Thank you very much, Professor.
Τώρα John που θα μπορούμε να μιλήσουμε λίγο στα αγγλικά, διότι ξέχασα τα ελληνικά.
We have maybe to mention to our students that you have an origin from Cyprus.
Yes, it's true.
And
but unfortunately,
you're speaking Greek.
I don't speak Greek. Well, I speak Greek when I am in Greece and in Cyprus, but δεν μπορώ να σας πω ότι σας είπα στα ελληνικά. Δεν ξέρω πώς λένε geostationary satellite orbit και πώς λένε frequencies και όλα αυτά τα πράγματα. Πρέπει να έρθω στην Ελλάδα, John,
we are waiting for you. We're looking forward to have you on our course.
Να κάθομαι στις κλάσεις για να μάθω ελληνικά τις λέξεις.
I think your accent and your Greek language is much better than.
But I'm so sorry I'm very proud of my Greek roots, of course, and I'm so sorry to not be able to speak in Greek. That I really need to maybe next year at least to make a short introduction in Greek.
Okay, that would be great for us.
Okay, merci, Nikos. I see that some of you are speaking French. Do you have questions?
Our students, as you know, are at the second semester of this master program. During the first semester, there was a course on telecommunications, and some of these issues maybe are familiar to our students. However, it was very insightful from your side. It was a very difficult topic, quite technically, and it would be great opportunity to have you summer course and maybe give a lecture on these issues. So if there is any question or something that would like to discuss on these topics, please, you are free to ask your question.
Because they had already a class on ITU, John?
Not exactly. It was on the spectrum and utilization spectrum. However, during this semester, we'll have the opportunity to have a class specialized in ITU, and maybe with someone who maybe you know him, is Mr. Nick Sinanis from ITU.
No, I don't.
In 2014, we were at the ECSL's summer course in Geneva.
Ah, okay.
And he was a lecturer back then.
Okay, no, I don't remember. But yes, if I come, I hope that I will be able to meet the students if I come to Thessaloniki in July. And also, you know that I said already last year that Thessaloniki is the first francophone city for Greece. I don't know why they say this, but they say that it's a francophone city. So
yes, maybe there were any special bonds between Thessaloniki and France. I don't know.
Maybe it will be an opportunity to reinforce cooperation between the University of Thessaloniki and the University of Paris-Saclay. Maybe.
This is in our intentions, and that would be great if we have this opportunity to develop any relations between these two institutions. We will discuss on this more afterwards, maybe. And
okay, so I see that there are no questions, huh? Students.
Maybe it was very clear whatever you said.
I will send you the presentation, so that you can share them with the students.
Okay, thank you very much. That would be very useful for our students. And maybe if there is no question for now, we would like all to thank you for being here today. It was very interesting. You were so descriptive on these issues, and as these issues are so complicated and so difficult, you gave a very clear perspective, and we appreciate it much.
Thank you, Christopoli. Θα τα πούμε στην Θεσσαλονίκη τότε. Okay?
Okay. Thank you very much. We'll be in contact.
Yeah, you contact me. Contact me not too late because I'm leaving mid-April, so before mid-April. Okay, John?
Okay.
So, merci beaucoup. It was a pleasure to be with you from Paris, and I'm very happy thanks to John, to talk to Greek students. It's also important because I'm far from my country, so with you I'm a little bit closer. Merci.
Thank you very much.
Ευχαριστώ. Γεια σας.
Γεια σας. Καλή συνέχεια σε όλους. Το υλικό θα αναπτύξω στο Dropbox. Το σημερινό μάθημα, κατά εξαίρεση όπως και μερικά ακόμη της Δευτέρας, ίσως διαρκέσουν περισσότερο, δηλαδή μεταξύ 2 και 3 ώρων. Μόνο για τις Δευτέρες είναι αυτό το πρόγραμμα, για τις Τετάρτες. Τις Τετάρτες είναι αυστηρά 2 ώρο. Θα τα πούμε την επόμενη, από ό,τι βλέπω είναι την επόμενη Δευτέρα, 3 Απριλίου. Καλή συνέχεια σε όλους.
Γεια σας. Καλό βράδυ.